I call the Honourable Philip Goff.
Thank you very much, Mr Speaker. Mr Speaker, Labor will be supporting this bill, but at the same time, at the Law and Order Select Committee that I sit on, we'll be examining it very closely because I think the quid pro quo for the changes that are being recommended here being acceptable is that there are adequate safeguards to ensure that there continues to be fair and timely consideration given to parole decisions. It's not often I talk about movies in this House, sir, but there's a particular movie that I remember very clearly called The Shawshank Redemption. And I remember in that movie very clearly the unfairness of the system that was prevalent in the United States at the time, where you got called up for parole but they were never going to give it to you. And that's taking the system in the wrong direction far too far, even when people had reached the point where they'd done their time, they'd shown remorse, they were clearly on a better track in their lives, and there wasn't much point in keeping them in the prison system. And even this government has acknowledged that keeping people in the prison system beyond the time it's necessary to preserve the safety of the community isn't a good idea. Mr Speaker, I put the 2002 Parole Act in place when I was Minister of Justice, and there was a huge amount of work that went into that new legislation, and that legislation brought in huge changes that I think have had major beneficial effects to New Zealand. The regulatory impact statement actually acknowledges that the reform put in place by the 2002 legislation has been really effective. It notes, and this was something that I insisted on in that legislation, that the Parole Board's paramount consideration, and that is the words that it used, the paramount consideration must be the safety of the community. That's exactly as it should be. The Parole Board has to be satisfied before they grant release on parole to any inmate that that person will not pose undue risk, that's the words that are used, to the public. And that considerably tightened the parole system. It put the public and the victims first. And when I say victims, the victims of the offending that saw the inmate put into prison, but also the potential victims if you let somebody out when it was inappropriate to do so and raised the risk that they would continue offending. And the regulatory impact statement produced by this government notes that the decisions made under that parole system that I put in place have resulted in a lot more prisoners serving a higher percentage of their total imposed sentence in prison. But it also makes this comment that is absolutely vital, that the result of that system is that the number of offences committed by prisoners between release on parole and the end of the sentence date has halved. The amount of offending by inmates on parole has halved, and that's a huge achievement, and that's a major vindication of what that Labor government did in 2002. Not only was the offending halved, but on the measurements of harm done to the community by people on parole, that had also halved. So the legislation was a lot tougher, it was a lot more effective, and it's produced the results. It's not flim-flam legislation, not designed to make the public think how tough you are on law and order. It was genuinely about the safety of the community, and that's the way that it needed to be. Well, that legislation is now 12 years old, and I'm happy for it to be reviewed. And on first consideration, I think that the changes proposed will be beneficial, and they'll be beneficial in particular to the victims who will not unnecessarily have to worry every time an inmate comes up for parole, even if that inmate is patently unready or unsuitable to be released on parole. And I and the Labor Party put a huge amount of emphasis on the position of the victim in society. The victim in the past too often has been the second consideration. It is the victim that comes first, and if a person in all likelihood is not going to be released on parole, why then put the victim through the trauma of having to attend the parole hearing or wait to hear the results of the parole hearing, all the time fearing what the result might be from the release of the person who offended against them, particularly in the case of very serious offences. And if you're in the situation of getting parole, generally the offences are very serious. So what we put first is the position of the victim. The regulatory impact statement makes much of the fact that there'll be a saving of about $700,000 a year. Well, you know, it's always good to save $700,000 a year, but that is not, I hope, and should not be the driving cause for this reform. I think the cause for this reform has got to be that if a person is ready to be released on parole, then they should be released. It is pointless and it's not right to continue to incarcerate a person who is ready for release. But we want to make sure that the person is ready for release. And the regulatory impact statement also points out many of the problems that we have. Most inmates go to parole 3 or 4 times before they actually are released on parole. And that indicates to me that probably we're taking people to parole too early. There is a safeguard that the prisoner, him or herself, can at any time ask for parole to be given if there's a change in their circumstances. And if a person has completed a program and they've come through and all of the assessments, and the assessments today are much more professional, shows that they're unlikely to re-offend, then let's get the person off the taxpayers' back, out of the prison, back with their family and back contributing to the community. And that is quite important. The other thing is, with the 12-month review that we have in the present law, because you have to do it within 12 months, many people are coming up at an 11-month period each time. So the period is actually shorter than the 12 months set out in the current legislation. Further to that, in many cases, the parole hearing is taking place before the offender has completed the program that they're on to address the causes of their offending. Now, that's a bit dumb, to be frank. You know, if you go in there and, as so many of our prisoners do, have an alcohol or a drug problem, and you're doing one of the programs that we started up, and this government, to be fair, has continued and expanded into your alcohol and drug problem, then you're not going to be released before you've completed the program. So why would you have a parole hearing, because you have to every 12 months, if you're working on a 17-month offender rehabilitation program that is going to vastly reduce the chances of your reoffending while in the community? So there's a certain amount of common sense in the proposals that are being made, and that is the reason, Mr. Chairman, why we're actually supporting this legislation before the House. I want to reiterate that while I'm in favour of not unnecessarily holding the parole hearings, while I'm in favour of those parole hearings in appropriate cases being unattended by the offender. Now, that sounds extreme, but there are many cases where the parole hearing, the second parole hearing, is just to get more information. If the inmate doesn't need to be there, and provided those rules are followed fairly and honestly, then I think there can be an exemption for the inmate having the right to attend that parole hearing. And there are other cases, sir, where the only work being done is technical work, where it doesn't require the attendance. There's also a provision for parole to be attended rather than in person, electronically. I've been in court when inmates have appeared before court hearings electronically. That works perfectly well. Particularly in circumstances where it may be dangerous to transport the inmate. So there's some good things happening there, but what we at the Select Committee will be doing will be looking to ensure that this does not obstruct the right to a fair and timely parole hearing, that what we do will be about common sense. It won't be about actually keeping people longer in prison. It will be about not having unnecessary parole hearings when it's patently obvious to everybody that the answer will be no. And finally, Mr. Speaker, but not last but not least, is that we need to make sure that what we are doing is consistent with all of the international human rights standards that we as a country have signed up to and have always acknowledged.
I call the honourable member